All right. Hi, everyone. Hello. Good morning. Welcome back. Welcome back. Everyone, nice weekend? Yeah, everyone make it through the fog okay? I'll part the fog this morning. I think it'll be a little bit more clearly. Hopefully, everyone's doing well. I thank you very much for the first class. I apologize I didn't have time to take any questions, but there's no way the first class. But today, we're going to have a much more engaging discussion. All right, so I'm going to pass around the seating chart. Please sit where you want. I don't really care, but if you put your name in a seat, stay there so I know who you are. And also, here's the roll. So if you could start here and just make sure your name is facing up. And that way, I don't have to. One of you will write your name upside down, I promise you. It happens every year. Someone writes their name upside down, they have to flip the sheet. Okay, so any questions before I get started? Anything in your minds? Okay, so far so good. All right, so as you can tell, we have a friend here. We have a temporary projector, which should be fixed next time. So I'm going to have to turn my head around a little bit more than I'd like to. So as far as the class, I assume we've all had the book. You all have the syllabus. The general overview is everything. The syllabus gives you everything you need to know. The schedule there is very precise, and I stick to it. Every single time I've taught any class, I've stuck to the schedule 100%. I don't fall behind. So if I say in these days we'll read these pages, read those pages. There's no guessing game about what you need to read next time. This requires a lot of discipline on my part, but I promise you it'll be worthwhile because we have a lot of material to cover, and you'll never be unsure of what you're covering in a given day. Okay, there's some information there about the exam. We'll talk a lot more about that later. If you want, you can see the exams from last year. I post them online along with the A+ answer. That very well might be useful for you. As far as attendance, sign the sheet and be prepared. This is really your benefit, not mine. If you're not prepared, it will impact you in the end of the class. So as far as interaction, the way I handle what you call recitation might be a little bit different than what you're used to. I go up and down rows, okay? And everyone gets one question. So I might start with this guy. I'll go like this, and then go to him, and then go start with you, and go all the way around, and go all the way around. Depending on how the class goes, I can do about 50 or 60 people per day. So there's no on-call list, but the odds are you'll get called on. There are about 70-something people in this class, so the odds are you will get called on. So you should be prepared. The reason why I do recitation like this is to make sure that everyone is engaged. I'm not a fan of staying with one student for about 15 minutes at a time because that one student perhaps knows it, and everyone else just prays they don't get called on, which usually ends up happening. So invariably, you will be called on. The flip side to that is if you're not prepared, I'm not going to dwell on you. I'm not going to yell at you. I'm not going to chew you out. If you're not prepared, this is really your demerit, not mine. I might push you a little bit, but if I see that you really have no idea what you're talking about, I'll move on and I'll remember that for next time when I'll come back to you, perhaps when you're not expecting it. So be careful when you're not going to be prepared. The course blog is everything. We're not using Stanley at all, so everything you need to know is in the course blog. I usually have this open, which is called the live chat. So if you go to today's lecture, okay, you'll see two links. My apologies, is very small. I don't have the projector set the way I like. But this here is a lecture notes, and this here is a live chat. Okay, these are two documents which I'll use instead of the board or PowerPoint. Okay, so if we click on this link for lecture notes, we'll open this. This is a Google Doc which you can use on your browser. If you don't have a computer, that's fine. You can look up here. It'll always be up here. This is where I'm going to type stuff. I won't put anything on the board. There won't be any PowerPoint. These are not meant to be thorough notes in any way, shape, or form. These are statutes or clauses from the Constitution or different texts I want you to think about. So don't rely on these as your class notes, but they may prove useful to you. The second item, so if you go back to the class blog for today, there's a link that says live chat. I realize it's probably way too small for you, so I'll make it a little bit bigger. So it says live chat, okay? This is what's called a back channel. And I've used this in different classes to varying degrees of success. Some classes really like it, some don't. So it'll be entirely up to you if you like it or not. This allows you to communicate with me and your classmates without raising your hand. And let me explain. You can type in messages here, and it'll be projected on the board. Okay? This is sometimes useful in a few different ways. So say, for example, there's a story we're talking about, and there's some current events link, right? If we link there, I can click on it. and that way I can show it to the class. Or maybe I'm in some sort of extended monologue, which I tend to do sometimes, and you have a question and I'm not calling on you. You can put the question there. My only reservation is you have to use your real name and don't put anything stupid. And I define that however I define stupid, because if you abuse it, I'll take it away. So don't take advantage of it. But I don't mind comments. I don't mind insights. I don't mind links. It'll be my discretion whether I keep it or not. Okay. Okay. So you have the lecture notes, you have the live chat, and you can always see these on the class blog for today. They'll always be the first 2 links. Okay. So here's the course schedule. And again, this is a schedule. We're not going to deviate from this unless some emergency happens or something. I don't know what happens. But we'll stick to this. And I'm very, very firm about that because I don't like falling behind, because then we don't cover stuff and then we have to rush at the end. If we do everything according to plan, we'll finish right on time and have enough time for review session. Okay. So I'd like to give you first now an overview of the entire class, which will take us from now till the end. And I apologize. Usually I have the screen here. I'll keep turning around so I can't make eye contact, which I don't like. So we did last week in the first class all the founding documents. Today we move on to a question which probably none of you have considered before. Why is our Constitution supreme? Right? Why do courts have such power to expound what the Constitution means? On Thursday, we're going to move on to a topic that's extremely important in the present day, which is the separation of powers. And we'll discuss various efforts where one branch or the other tried to seize more power than they should have. Next week, move on from the presidency to the legislative power, right? What is it that Congress can do? What is it that Congress cannot do? Okay. After we finish that, we'll come back to the presidency and talk about the executive power. And specifically, how does executive power interact with Congress, which is an overarching theme. Okay, then we move on to more of the executive power. How can the president remove officers? We'll explain that. Class 7 is going to be something of a current events class, but not so much. What does it mean for the president to actually execute the laws? The Constitution says the executive shall take care that the laws be faithfully executed. What happens when the executive does not want to execute the laws for whatever reason? And we'll discuss that at some length with some focus on the immigration debate going on now. After that, we moved on to executive powers in foreign affairs. And I will want to talk about ISIS or ISIL, whatever you want to call it. We have a lot of undeclared wars at the moment, so that might be something that would be worthwhile to discuss. Then we move on to the scope of federal powers, leading us into the Commerce Clause, which is what we'll spend significant amounts of time on. How the evolution of the Commerce Clause has expanded the power of the federal government in many ways. Okay. Then move on to the spending power. Okay, and then we move on to my favorite, perhaps isn't the right word, but a case that I've spent a lot of time on, which is Obamacare, and we'll have an extended lecture on that, which I think you will all really, really enjoy. Okay, that's basically the first half of the class. After that, we move on to the 14th Amendment, which are the Reconstruction Amendments, which ban slavery, which require equal protection of the law, and which require the right to vote to the freed slaves. And we will go through that. Then we discuss what power Congress has to enforce the 14th Amendment. It's not just the courts, it's also Congress with these powers. Then we move on to a topic which I'm sure we'll have a lot of passionate discussion on, which is equal protection and segregation. And then the flip side to that is equal protection and desegregation. So we'll run the entire gamut of the court cases legalizing segregation and the subsequent cases which find that segregation is unconstitutional. Then you have your spring break, you can enjoy that. When we come back, we'll talk about affirmative action, and we'll focus on the recent case from UT Austin decided a couple of years ago. Then we'll do race and gender discrimination. And how do I do it? We will do something on gay marriage later. And if my math is right, and I actually timed this almost perfectly 2 years ago, well, the class within maybe a week or two of the Supreme Court same-sex oral arguments, it'll be really close. So you'll be fully prepared for the same-sex marriage cases. I might be off by a week or two, but I'll be pretty close. Then we'll move on to what's called substantive due process and what's often known as economic liberty. Do you have this right to earn a living that the courts can protect in the Lochner case, which I'm sure some of you have heard of? We'll move on to individual liberty, which these are cases which lead to discussions of contraceptives and ultimately abortion and Roe v. Wade. Okay, yes. So this is actually when we're going to discuss the gay marriage cases. And if my math is right, and there's no schedule yet, the Supreme Court will hear arguments in the gay marriage case roughly April 28th or so. So we'll be within 2 weeks of the gay marriage cases, which is pretty good timing on my part. I wasn't deliberate, but I had a feeling that's when it would be. Okay, then at the end, 2 years ago, I actually timed it perfectly with the United States versus Windsor within 2 days of the argument. That was very good, but not deliberate. We will do a little bit in the First Amendment, not nearly enough, but just enough to whet your palate. Even if you never even want to do First Amendment litigation, I promise you'll come up if you ever do labor law or any kind of retaliation for being a public employee. The First Amendment is important. So we'll talk about the freedom of speech in 2 classes. And we will briefly do freedom of religion. This is such a voluminous topic that has so many nuances that I can't even come close to doing it justice. I can't. But you get 1 class on it. And the last class, for something a little bit lighter, and this is Texas, we will cover the Second Amendment, and we'll get a nice discussion of originalism and how to read the Constitution according to its original meaning. And at some point after that, we'll have a final exam. So that's the class. And like I said, this is going to be it. Make sure you keep on top of the readings. They're probably a little bit heavier than your other classes, which you'll notice is also a 4-credit class, so they will be. Also, unlike most of your other first-year classes, there's only Conlaw1. There is no Conlaw2. That's all, folks. This is all you get. At most other law schools, you have 5 or 6 hours of con law and less property, for example, which I also teach, but here you have 4. So we're going to have to give you a lot, as much as you can. I know it's going to seem like a lot, but you will enjoy it. You will have certain skills which other students will simply lack, and this will help you in almost every aspect of your careers, whether or not you actually do any federal court litigation. Okay, any questions before we get started? Okay, you see why I couldn't do this 10-minute spiel last week. I didn't have time for it, but this spiel takes about 10 minutes. All right, so let's go back to today's class. And I framed the question, right? Why is the Constitution supreme? Okay. Now, how many of you have ever studied or at least heard of the case of Marbury versus Madison? Oh, okay, good. Almost all of you. How many of you before today ever actually read it? Wow. Of those who read it, how many actually understood it? Good, good. About the same number. That's good. This is the case that torments law students for reasons which I think are, not exactly fair. But this is a case that's probably one of the most important in the history of our court system. All right. So I'm going to start back in the corner. I don't have your names quite yet, so please, when I call you, just say your name. What's your name, sir? Robert? Okay, Robert. And by the way, I prefer first names. You can call me Josh. I don't really care for professor, and I'll call you your first name as well. So is that okay, Robert? Okay, I can do Rob. All right, Rob, let me ask you a question. Why do people listen to courts? This is a question which you never thought of. Person next to Rob, what's your name? Awesome. Awesome. Why do people listen to courts and listen to judges?
Actually, they have to.
They have to. Well, why?
Because I guess they make a ruling on something, and then the executive branch enforces that.
Well, why does the executive branch have to listen to the courts?
I'm sorry.
Why does the executive branch have to listen to the courts?
I guess we go back to the whole thing of checks and balances.
Why do we have these checks and balances?
To make sure that one branch doesn't get too powerful and end up with another branch of government.
So what's your name? Yeah.
Hugh.
Hugh. Why do you think people listen to courts?
I feel like listening to courts for a lot of reasons. One, society as a whole needs structure, and business they have to have structure. They also need some courts in the room because the executive branch, as I said, enforces it.
Okay. So I'm getting generally from you, but from all of you, is the reason why people listen to courts is because it's a good thing, right? It promotes certain values. It checks the other branches, perhaps. But none of you actually answer my question, right? Why does anyone actually need to listen to them? It's good enough to write a constitution, have these different departments, right? You know, the courts and the legislature and the executive. But when the courts do something the executive doesn't like, what's your name? Lou. When the courts do something executives don't like, why can't the executive simply ignore the court? What's going to happen?
Not sure.
Well, think about it.
I feel like the judges are a man of ambition and just
Ooh.
bound by the Constitution.
You used the word. Good word. I don't know if it was deliberate, but you used a very good word. Ambition. What does that mean, ambition? You don't have to look it up. Tell me in your own words. What's ambition?
I don't know, like a good definition.
Ma'am, what's your name?
Shelby.
Shelby, what's ambition?
Drive to succeed.
Ooh. Are you ambitious? How many people in this room would say they're ambitious? Raise your hands. Okay. You are all in law school. You took the LSATs. You studied your butt off. I would say you are all ambitious. Now, Shelby, is it bad to be ambitious? Everyone agree? I think it's safe to say, and everyone agree, that it's in our human nature to be ambitious, right? But what's one of the problems, man? What's your name?
Lauren.
Lauren, what's one of the problems when we have a lot of ambitious people? Maybe not in this law school, but perhaps elsewhere. What's the problem when we have a lot of ambitious people in one area?
Because their ambition is most definitely going to be different from another person's ambition.
Uh-huh. Good. And then what's the result of that?
Chaos.
Is it chaos? Now, let me ask you a slightly different question. Okay, so what's your name? John, let me ask you this question, right? Say you had a class with a couple really ambitious students and the rest of them didn't give it down. What would happen in that class? Or business or law firm or whatever else? The curve would, well, you'll see the curve usually works that way. But in theory, say in a law firm, not a class, right? And you had a couple really ambitious people and the rest of them didn't really give it down. How do you think the dynamics work in that law firm?
Well, the ambitious people are going to kind of take charge, take lead, and
Yeah.
the others are going to kind of follow.
Yeah. So it's interesting, right? Is that when you have some people that are really ambitious, people in this room, and then you have people who aren't so ambitious, you said they'll take lead and take charge. And ma'am, what's your name?
Renee Garcia.
Renee, thank you. Now, what happens, let's say it's not a law firm, let's say it's in the government. And let's say you have some people in the government that are really ambitious, other people, meh, right? They don't care. What do you think that government will look like?
Probably, they're probably weak, like a weak government.
Would the government be weak? Think very carefully. You have a couple people in the government who are very powerful and ambitious, and the rest of them don't really have much say. What do you think will happen? How will that government look?
Unstable. Or
Oh, I think it'd be very stable. What's your name, sir? Me? Yeah, Plummet. Plummet. How do you think that government would look?
I think it would be an oligarchy.
An oligarchy. Explain.
Well, like I said, you have a few people who are very ambitious, and when it's already established, they will likely be the ones to take charge, and they'll run things the way that they want to run things, and that actually, in my opinion, would lend itself to somewhat of a stable government, although you might have what the framers call despotism.
Well, dictatorships tend to be very stable, for sure. If you want stability, put a dictator in power, right? You go to some of the most stable countries, military juntas are very stable, right? Until they get overthrown. So if you want a stable government, get a dictator. So, man, what's your name?
Lauren as well.
Lauren. Oh, two Laurens, they'll be easy, right? So Lauren, when you have this kind of oligarchy or dictatorship, right? Is it possible for anyone to stop that in the government? What's the only way to stop that?
Well, it's more difficult.
Why is it more difficult when you have these ambitious oligarchs, these ambitious dictators? Why can't anyone else stop them?
Because if they decide to work together, then they can influence all the people who are less ambitious and easier to follow along.
Good.
And they can kind of self-perpetuate and make them stay in power for longer.
Right. And this is a lesson that's old as time, right? When you have certain people in power, they're ambitious. Unless there's other people with certain powers, the oligarch will run away. So, what's your name, sir?
Michael.
Michael, what do you think? What insights do you think we can glean from this discussion of ambition? And please pass the seating chart back up if you're done as well. Michael, what insights do you think we can glean about ambition? About how do you think we should best structure government to prevent that oligarchy that Plowman mentioned?
You need a balance.
A balance of what? Ambition. Turn to Federalist 51. I don't know if it was deliberate, but you put me in a good tear. Awesome. or Lou, whoever said it. Okay. Turn to Federalist 51, right? There's a line. I don't know what paragraph it's in, but I think it's on the second page. Madison in Federalist 51 is discussing how to structure the government in a way to prevent a dictatorship or a tyranny from emerging, right? Okay, I think it's on page 120, 129, okay? Madison was trying to structure the government in a way to minimize the risk of this ambition, okay? And then what's your name? Sarah? How does Madison approach this task of preventing these, ambitious oligarchs from taking over? What's his approach?
Just kind of by insulating them from corruption of the powers. Like they'll get provision that guarantees their salary to keep them.
We're talking about judges now, right? Okay.
As far as the judiciary structure.
Let's go to the judiciary in a few minutes. Let's talk more about the executive and the legislature, right? How does Madison propose dividing up this power? Demi? What do you think? How does it think it's possible, right, to eliminate this ambition?
I don't think he thinks it's impossible, but it's going to be difficult. He's trying to keep the independence between the three separate
Okay.
actors of power.
All right. Let's see. Now, what's your name? Haley, do you think it's possible to ever get rid of individual ambition to try and strive and grab more power? Is it ever possible to do that?
I don't think so, not completely.
It's not. Let me give you a little bit of wisdom. All of you are very ambitious. There's absolutely nothing I could ever do to make you stop doing something if you want to do it. I can give you a bad grade, I can give you a bad recommendation, whatever, but if you are intent on doing something, I know I can't stop you. I would never try to. This doesn't just apply in law school, it applies in government. If you have a person in government who's hell-bent on amassing power for himself, there's no way you can stop that ambition. It's not possible. We'll read later in Federalist number 10, which Madison also wrote, about factions, right? And he basically says the only way to kill factions is like killing a fire, which is by taking away their oxygen, right? The only way to stop ambitious people is to kill them. And I'm not exaggerating. But you don't need to kill the ambitious people. Ambition can be good. What you have to do is to check ambition, which when you use that word, I went for it, right? This is on page 128, right? Madison writes one of my favorite quotes of all time. It's up there. Ambition must be made to counteract ambition. Sir, in the purple, what does that mean? Ambition must be made to counteract ambition. What does that mean?
For people to control other people, separating separation of power.
I don't know what you mean. You got to flesh that out more.
I guess people must check other people with their ambition.
Okay, well, let's try this one, right? Let me ask you a follow-up question. What is the primary purpose of government, according to Madison?
Control or to secure the liberty.
Okay, what do you mean by that?
Basically to preserve liberty.
Ma'am, what's your name? Chloe. What does Madison say is the first goal of government? What's the first end that government must accomplish?
The government has to control the governed as well as the
Yes. Yes. Okay. Madison writes, in framing a government, right, the first end is to control the governed. It's to keep the people in check. But Chloe, finish it up. What's the second obligation of government? Yeah.
Well, yeah, and then to control itself.
Okay. And here's the insight of Madison, who was a favorite of mine. James Madison, of course, from Virginia, one of the framers of the Constitution. He was also one of the authors of the Federalist Papers. So those of you who don't know this, the Federalist Papers were authored by James Madison, Alexander Hamilton, and John Jay. These were a series of anonymous pamphlets written in 1788 to try and persuade people to ratify the Constitution. And they were written under the pseudonym, the fake name Publius. These were papers trying to persuade people. So these are one of the greatest insights we have to what the Constitution meant at the time of its framing. We will revisit these often. But in Federalist number 51, Madison says, listen, first purpose of government, right, is to control government. But the second is that government has to control itself. You know, like check yourself before you wreck yourself. Basically this, government has to make sure that the people are in control, but it's not so controlling that the government gets out of hand. Thank you, sir. So what do we have? We have these two insights. Ambition must be made to counteract ambition, and the government must control itself. Okay. Madison frames this in one of the most eloquent passages in the entire class, and I'll read it to you in its entirety. But what if government itself, but the graceful reflection of human nature? Ready for this? This is beautiful stuff. You don't get much beautiful prose in this class. This is about it. If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls of government would be necessary. Right? If we were perfect, if we were infallible people, we wouldn't need any government. There would not need to be laws. But we are not angels. Far, 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 far from it. We are fallible. We have ambition. We have evil inclinations. And the only way to prevent this evil from disrupting our government is to check it with more ambition. This is what we mean by the separation of powers, right? This isn't some sort of, highbrow discussions like, oh, well, we have the Congress on this building, we have the president in that building, and the Supreme Court in this building, right? This is a matter of architecture, right? These are actual links in a chain that are meant to butt against each other. And as I read to you last week, the entire Constitution, I hope you start picking up on these themes, that at every single juncture, each branch has ambition, which is made to counteract the ambition of the other. So when you have an ambitious president, he won't get very far because Congress is also ambitious. The president wants to enact one agenda, the Congress has another, but guess what? Unless the Congress passes a law, the president can't do it. At least he's not supposed to, right? So at every juncture, You have this. What if you have a very ambitious court? Right? What if you have a judge that goes off the rails? Well, that judge can be impeached. Okay? What happens if you have a tyrannical government, a tyrannical member of Congress? He can be impeached. What happens if you have a tyrannical president? Well, he has to be reelected. And the election is by people in all the states. At every single step, there are so many pieces fitting in, which is designed, right? We can't trust people. We are not angels. We're not angels. I am not, right? The only way to stop ambitious people is to put other ambitious people in the room and hope they fight each other out, and only the best policy survives. Only the best policy that reflects the will of the greatest number of people will make it through. So you have one group here that wants to do X and another group that wants to do Y, and they're fighting against each other. What's probably going to happen? The middle ground. The middle ground will happen because they need votes from across the board. You need majority votes. This is the ambition. I'm sorry, this is the vision of our Constitution, and in my humble opinion, why it's lasted 200 years. You can have the most beautiful Bill of Rights in the world that protects rights of free speech, rights of housing, rights of healthcare, rights of food, rights of education. You list them. But unless you have the checks and balances to ensure they can be implemented fairly, they're meaningless. Right? If one day you have an executive that decides, you know what, I'm not going to enforce these laws, I don't like them. Unless you have a Congress that can make him enforce it, the Bill of Rights is worthless. That the problems of despotism arise when power is not checked by each branch and ultimately by the people as sovereigns. Never forget, all of you vote, all of you should vote. Your vote is the source of sovereignty of the government. This is where the authority derives from. Okay. Yeah, write down in your notes, ambition must be made to counteract ambition, and highlight that. We'll come back to that phrase probably about at least a dozen times this semester. But it's such a powerful phrase that captures it so well. The Federalists are beautiful. Before this class, how many of you actually read from the Federalists? Oh, good. Last year, not so much. That's good. We'll read a bunch of them this year. I know the language sometimes a little bit hard to understand, but take your time and read it twice if you need to, because you'll learn a lot more from that than you ever learned from me. Every time I read them, I see something else. There's a lot of wisdom in those papers that we can learn from. Okay. So any questions on that? Any questions on the Federalist or Federalist 51? Thank you for saying ambition. I wasn't planning on doing that yet, but you led right into that. Was that deliberate?
I read it.
Good. Take credit for it. Good. Perfect. All right. So now we'll come back later to how Madison decided to separate the powers of the executive and the legislature. That'll be in Federalist number 10, which we'll do in a couple weeks. But I assign after Federalist number 51, Federalist number 78, which is authored by Alexander Hamilton, who was a very interesting guy. He was, among other things, the Secretary of the Treasury. He was a young adjutant general in George Washington's Continental Army. Really interesting guy. He died, of course, in a duel with Aaron Burr, which is somewhat unceremonious. He died in New Jersey at that, not where I want to die. I'm from Staten Island. You'll get a lot of Jersey jokes this year. Okay. So let's move on to Federalist number 7. So in our constitutional structure, right? Where was I up to? Okay. So start in the back. What's your name? Ian. Thank you. Ian. So in our constitutional structure, right? How are members of Congress sent to Washington? By the states? Be more precise. Good. Let's be very precise. So the members of the House of Representatives are voted by the people of the states, right? So what's your name? Connor. Under the original Constitution, before it was amended, how were senators selected?
By the state.
Exactly, right? So by the state legislature. So originally, members of Congress were sent by the people. Members of the Senate were sent by the state legislatures. And this had a very important separation of powers context, right? The people, sovereigns, could pick the members of the most representative branch, the House, and the state legislatures who had interest for state concerns would send people to the Senate. Okay? And so what's your name? Oh, I have your names. Oh, what am I doing? Yeah, Jacob. Jacob, how is the president chosen? Be more precise. You know the answer. Which college was Harvard, Yale? Yeah, yes, the Electoral College. Very good. Now, many of you never actually study how the Electoral College works, and it's more complicated than it's worth explaining. But more or less what happens is when you vote for president, so 2016, when all of you vote for president, you're not actually casting a vote for a candidate. You're not voting for Hillary Clinton or Rand Paul or anyone else, right? You're actually voting for a series of electors. And these electors that basically pledge their votes, either Rand Paul or Hillary Clinton or Ted Cruz, whoever, right? If you do this, you're not voting directly for the president. In theory, at least, and this has never actually happened, the electors can decide to cast a vote for someone else. These electors were meant to be a check against popular opinion, that they were able to push back against the radicalism of the people, okay? So at every step of the way, every step of our government, there's all these stumbling blocks, or hurdles, if you will, to putting people in government, okay? And what's your name? Oh, I know your name. Is that Karishma? Karishma, how long are members of Congress, members of the Senate, and the president in office for?
I guess I'm Canadian.
Oh, you're Canadian. Okay. I'll come back to you. Are you, Maurice? What are the terms? I'll come back to you. I promise. I'm sorry. What are the Maurice? What are the terms of members of the House, Senate, and the presidency? 246. Yeah. So members of the House are 2 years. Members of the presidency is 4 years, and members of the Senate is 6 years. Okay. Now, Krishna, this one you'll probably know. How are members of the courts chosen? They're appointed. But let's be very precise. How are they appointed? Good. Okay. So it's interesting about federal judges, right? I always have one Canadian. Always have one. Usually I have one last year. Is that right there? Okay. Unlike every other aspect of the United States government, judges aren't elected. They're, as Krishna correctly said, they are appointed by the president. But is it only the president, Brandon, that's involved in the situation? The Senate has to give what's called advice and consent, which basically means 51 votes. So today, well, a majority of the Senate has to approve the judges. So even here, the president can't unilaterally appoint judges. He must do so with the advice and consent of the Senate. Is that Morgan? Morgan, once judges are appointed, though, what's their term? Life. To be precise, it's during, quote, good behavior. So as long as they don't misbehave, they can stay in office. Okay? And by the way, there's only been maybe a dozen judges in 200 years who have been impeached. So basically, you can really mess up and stay in office. Okay? Lauren, is issuing an opinion Congress doesn't like sufficient grounds to remove a judge? Is it? Well, today, perhaps the answer is no. But why does it have to be? Why is it that, is there anything in the Constitution that says Congress can't remove judges because they issue decisions they don't like? What do you think? What do you think? Is that Zachary? What does the Constitution say? I just said a second ago. Is it a life term? Good behavior. Okay? So in England, under the king's reign, the judges served at what's called the king's pleasure. At the king's pleasure. Right? That basically means so long as a judge issues decisions the king likes, his salary will be maintained. But we, in our Constitution, chose a different standard. They remain during good behavior. So as long as they don't, break the law or like, take bribes or do something really stupid, they can't be removed because the Congress doesn't like them, right? Is this Jonathan? Can Congress then just cut their salary?
I think it's determined pretty determined.
Can it be diminished? You already answered it.
I don't think so.
That's right. Congress cannot decrease the salary of a judge. Once a salary is set, it can't be diminished. Now, they don't have to raise it either. And this has been actually a huge problem. Yeah, for about 20 years, judges have been complaining that they haven't got any raises. They've effectively said, the cost of living adjustment is basically every year your salary goes up like 1 or 2% to adjust to inflation, whatever. Most jobs have these. Courts don't. So their salary's been the same for 20 years. And they've been actually suing, citing this clause of the Constitution, but they haven't gone too far. Anyway, so you have these judges, right? They're not elected. They can't be removed for issuing decisions that are unpopular. And their salaries can't be diminished. And, life expectancies today are a lot longer than they were in the 1700s. So judges can serve for 20, 30, 40 years. Is that Gabrielle? Gabrielle, how do we check the ambition of judges? How do we check the ambition of these judges? They can't be thrown out of office for doing something bad. They can't have their salary diminished. The people can't remove them. How do we check the ambition of judges? What do you think? Well, I think I see where we're going with this. What did Hamilton say in Federalist 78? How did Hamilton describe the courts in Federalist 78? The least dangerous branch. Write that in big letters in your notes. Hamilton in Federalist 78 called the courts the least dangerous branch. Right? Is it Emily? Emily, why did Hamilton say that the courts are the least dangerous branch?
Well, he says that they have neither force nor will.
Neither force nor will. What do they have? Judgment. Right? This is one of the most famous quotes in the entire thing. Right? I highlighted here. I apologize. It's too small, but I'm on this temporary projector, so I can't get I'll get it better next class. Okay? This is in the second last paragraph. Hamilton says, it may truly be said to have neither force nor will, but merely judgment. Right? Emily, what does that mean? Neither force nor will, but merely judgment. What's Hamilton saying there?
It might seem like they have the power to.
What do you think? Is that George? George, what do you think that means? That the courts have neither force nor will?
They have the judgment, but they can't whatever they said.
What do you mean judgment? What? Try and define it without using the word.
To say what their opinion interpret, and they mean whatever the issue
Uh-huh.
is, but they don't get to enforce that.
Does anyone have to listen to them?
Well, no, I guess no. But
And this full circle brings us back to the question I opened with. So what's your name? James. Is there anything that Hamilton says that requires the executive to listen? Listen to the courts? The answer is no, right? There's nothing in the Constitution itself which explicitly says the courts have a power to invalidate laws. There's nothing in the Constitution that requires this power of what often is called judicial review. The Constitution's silent. What does it say? Well, we did the text last week, right? We said last week that the courts, Article 3, right? I have it here. Sorry, I'm a little bit disorganized for this projector. Okay, right? You have this judicial power. You have this judicial power in the Supreme Court and other courts that Congress may establish. There's nothing in the Constitution that says courts can find laws unconstitutional. There's also nothing in the Constitution which says the executive has to listen to the Supreme Court. There's nothing in the Constitution that says states have to listen to the Supreme Court. Nothing. But that can't be right. We have 200 years of history, and you have a very thick book in front of you of all instances where the court has said stuff and people have listened. Or hasn't. Okay? So I'd like you to turn to the reading on Cooper v. Aaron. It's on page 163, please. Is anyone here from Arkansas or Little Rock? Anyone ever been to Little Rock? Did anyone ever visit in Little Rock this place? You know what this place is? Anyone? Raise your hand. Yeah. What's Central High School? Yeah. So this case is probably one of the biggest constitutional crises we ever had in this country. I ask you at the outset, why does anyone need to listen to courts? And you might say, oh, well, the Supreme Court decided what the Constitution means. Says who? So I'm sure you've all heard of the case, very famous case, Brown versus Board of Education, right? This was a case in the 1954, 55, where the Supreme Court will study this. They didn't actually desegregate schools. It's actually a common myth. They said some stuff, and they said, with all deliberate speed, make some changes. But they basically said segregation in schools was unconstitutional. We'll do that opinion later. A lot of governors in the South said, no, you're a court, I'm a governor. Make me, right? Chief Justice Earl Warren, come down here and make me open the schoolhouse gates. And this came to a head at this high school. Actually, visited a few months ago. It's still an active high school. It's an amazing building. It's huge. But this is Central High School in Little Rock, about maybe a mile from the Capitol. And you had 9 African-American students who were called the Little Rock 9, who tried to enroll in what was then a white high school. Now, under Brown v. Board of Education, a number of other court decisions, there were orders in place saying, you need to desegregate. You need to admit these 9 students to your school. And there's this famous scene, and it was actually very powerful, where they're trying to walk up the steps. And I walked the steps myself. They're huge steps, and they go to the front door. And I mean, it's a huge building. And let me find the picture. And they go, yeah, this is it. And they go to the front steps, and they see the governor standing there with some troops, denying these students the power to enter in the school. Mind you, the Supreme Court and other federal courts had said, you need to desegregate these schools. But yeah, the governor standing there with police, blocking these students' access to a school. What the hell do you do then? The Supreme Court made its ruling, and you had the governor, Orville Faubus of Arkansas, blocking the doors to the schools. This also happened, maybe any Roll Tide fans, at the University of Alabama. Governor Wallace blocked in Tuscaloosa access to black students to the campus. So this was not only in Arkansas, right? So what the hell happened? Anyone know what happened? Yep. President Eisenhower mobilized National Guards. They got in there. And the National Guards escorted these 9 students into school. And I mean, they stuck with them. They basically brought them right into the principal's office because otherwise it would have been lynched. I'm not exaggerating. Right? I mean, it was pretty violent. You can't really tell from this picture, but there was a mob scene outside the school. All these people. So they basically escorted them right into the school. Okay. What happens if, say, instead of having President Eisenhower, you had President George Wallace, a segregationist, in office? Would he have sent the National Guard to open up the schools? Probably not. Then what? Right? Then what? You had a Supreme Court that made its ruling, and a governor of a state ignored it. What then, Pedro? What happens when you have the governor of a state ignoring a Supreme Court order? What happens then?
Well, they'd be going against the vow they made to uphold the Constitution.
But who gets to decide what the Constitution means? I'm very glad you said that. Every officer of the United States, state and federal, takes an oath to the Constitution. But who gets to decide what the Constitution means? Today, we take it for granted that it's the Supreme Court. But that does not appear anywhere in the Constitution. And in fact, Governor Faubus said, the Supreme Court doesn't get to decide what the Constitution means. I decide what the Constitution means for me. So Pedro, let me ask you again. Is it absolutely true that the governor was violating his oath?
Well, if we establish that the Supreme Court decides what the Constitution is.
And who establishes that?
Well, yeah.
The Supreme Court. You see, exactly. You see the issue here, right? And I'm not criticizing this at all. In fact, I'm a fan of the Supreme Court, a huge fan of it, right? It's a fantasy of mine. But there's no requirement in the Constitution that it's the Supreme Court that decides what the supreme law of the land is. None. None. And Governor Faubus in Arkansas said, you know what? I don't think Earl Warren and these justices can decide what the Constitution means. I'm going to decide what it means. So is that Gabrielle? No. Okay, Gabe. Gabe. So let me ask you the same question. Let's say wasn't President Eisenhower. Let's say it was a segregationist in the White House back before, right? And he didn't send in the National Guards to help these children go to school. What happens then? I mean, this is a serious crisis. I mean, what actually happens at that point?
I guess I have to wait until somebody gets into office that can rule that.
What happens to the court? What happens to the court if people start ignoring it?
Balances out.
It what?
It balances out.
What do you mean balances out?
They
And what's your name?
Yasmin?
Yeah. What happens? What happens if people start ignoring the court, Yasmin?
They start to lose influence.
They lose influence. What do you mean influence?
Well, nobody will listen to their judgment.
Ah, exactly. This was the question I started with, right? Why do people listen to courts, right? Yasmin, I think, said correctly, people will stop finding them accountable. Their credibility as an institution will go away. Because if Arkansas ignores the Supreme Court, why can't Alabama ignore the Supreme Court? Why can't Mississippi or Texas ignore the Supreme Court? You see how quickly this crumbles, right? This is a very fast endgame. The legitimacy of the courts, right? The court's legitimacy only goes so far as people respect their judgments. When people no longer respect their judgments, the court's done. This happens very quickly, right? Eisenhower recognized this. That's why he sent the troops in. Eisenhower wasn't a big desegregationist. That wasn't his thing. Actually, something to his demerit. That wasn't a big thing for him. But he recognized what happens if the Supreme Court makes a ruling and you have these states starting to ignore it. The entire fabric of our separation of powers implodes. Like, you ever see, like, when they have like an old stadium and they just implode it? Yes, that's what it looks like. And it happens very fast. This is what we might call a constitutional crisis, right? We've had a number of these over the years where stuff could have gone really, really bad. And, due to the light of the Almighty, or I don't even know what, we averted this crisis, right? We averted this crisis. Justice Breyer often gives this talk, and he talks about this Little Rock case, the Little Rock 9 case. And he mentions this thing, listen, there was no requirement for the governor of Arkansas to do this. You had to send in troops with guns. Say, okay, you know what? You want to start a civil war? Go for it, buddy, right? You want to open fire on federal troops? Good luck. Lincoln fought a civil war. What was a civil war over? Well, the first answer, of course, is slavery, right? But the actual underlying answer is actually impacted by whether southern states could ignore federal law, right? Can the southern states ignore the Constitution? Lincoln's entire justification for the Civil War was that they weren't following the Constitution, that the southern states weren't. As commander-in-chief, you can put down the insurrection. Lincoln never acknowledged it was actually a civil war. He would never say that. He said they were just in rebellion, which is very deliberate, right? A more contemporary example, which I think all of you were alive for, or yeah, at least for the time being, was Bush v. Gore, right? You had a Supreme Court decision that stopped recounts. You have other countries where there's a dispute over ballots and people pull out their guns. They start fighting and killing each other. Al Gore, to his credit, right, didn't agree with the recounting. So what did he do? Did he go for his gun? He went to the courts, right? Now, people often think of Bush v. Gore as a horrible decision. We'll talk about it later. But I want you to focus on one thing. When you had two candidates for the presidency who did not agree, they didn't turn to violence. They turned to the law. Now, whether the law worked or not in that case, we can talk about that later, right? But they actually went to the courts. And you want to know what? The courts made a decision on a 5-4 basis. And there weren't bloody revolutions. There were no pitchforks. There was no, there was no guillotine being wheeled out. People respected the judgment. Al Gore, if you read his concession speech, said, listen, I followed this case. The Supreme Court ruled. I'll stand by it. I'm sure he was bitter and sore about it, right? But he accepted it. That for better or worse, for 200 years, a court as an institution has gotten itself involved in these really messy issues. And they still come out looking pretty damn good, right? If the percentage of people who favor the Supreme Court is much higher than that of Congress, the presidency. You probably don't know much about it, but people have a generally good impression of the courts because they need to. Once a court loses that legitimacy, we go the way of Venezuela, right? We go the way of any two-bit dictatorship. It's not very far away. So the courts have a very essential role. Go ahead.
Isn't that a pretty fragile position?
Yes.
Though?
Oh, it's yes.
Because as soon as the executive branch decides not to send those, the National Guard or whatever,
It's over. It goes very quickly. This is why, and we can speak of divine providence or whatever you want, but we've had so many of these crises in our country, which we'll talk about, and at every juncture, something saved it. Something saved it, and I for the life of me, I told you Magna Carta, which was this great document that lists the certain liberties of the Englishman, was signed in the year 1215, and I'm taking a class on it now online. I take classes also, and one of the questions is, right, why is it that this document has prevailed for 800 years, whereas in all these other countries they kind of went through all these various revolutions? I don't know the answer. But by whatever force, we've had one miracle after another that prevailed. And there's lots of bad stuff that happened also. But at the end, in the year 2015, we have the same Constitution, we have the same Supreme Court, and we're still studying Marbury versus Madison, which is where it all begins. Okay? Okay. So any questions from the Federalists before we do into Marbury? Okay. Yes, sir.
How fair was it that when that whole recall of Bush's law that appointed, I think it was like 2 judges, the Supreme Court at the time, they didn't do it.
Well, he appointed 2, but 1 voted against him. Right. We'll do Bush v. Gore a little bit later. I don't want to focus on the merits, but the fact that they actually went to the courts is a significant issue that people didn't turn to guns, which is often what happens whenever there's a disputed election. Okay. Okay. So let's move on to Marbury versus Madison. And I'd like to give you some of the background of this question. Okay. You want to talk about a precarious state in American history, you need to focus on the year of 1800. Okay? What happened in the year 1800? Well, we all know that the first president of the United States, well, actually, the first president was John Hanson. He was the president of the Articles of Confederation. You will win bar trivia one night with that, I promise. But the first president under the United States Constitution was a sterling man named George Washington, whose character was far beyond his time. And George Washington served 2 terms, basically unopposed. Okay, and then George Washington said, "You know what? I've had 2 terms. Let me put this down and go back to my farm." And that decision to retire, there were no term limits in the Constitution, but that decision to retire for 2 terms set a tradition which every president until both Roosevelts followed, both of them. Thankfully, Teddy didn't win the 3rd time, but FDR did. After Washington stepped down, his vice president was a guy named John Adams, who was a fairly prominent figure in Boston. And he ran for president in 1796. And his vice president was a guy named Thomas Jefferson. Now, Adams and Jefferson hated each other. They absolutely despised each other. They eventually had a coming together later in life, but they really did not like each other. So you had Adams running against Jefferson and another guy named Aaron Burr. Okay, Aaron Burr was the guy who killed Alexander Hamilton. These guys were all friends. It's kind of it's really incestuous when you think about it, but they all knew each other. Okay, so the election of 1800, you want to look at disputed elections. There was a tie. There was a tie in the Electoral College. What happens when there's a tie in the Electoral College? It goes to the House of Representatives. And basically, the House of Representatives votes to see who the next president will be. You want to talk about one more? At the time, Thomas Jefferson, as vice president, was president of the Senate. Do you know who's responsible for counting the electoral votes? The president of the Senate. Thomas Jefferson counted his own electoral votes. And there were a couple that might have been disputed. But after Thomas Jefferson's counting of his own electoral votes, it yielded a tie. Okay? Mind you, our country at this point was, what, like 12 years under the Constitution. It was pretty new. And you had 2 presidential candidates who tied in the Electoral College. Has that ever happened before? Like 14 years ago, right? This was a major crisis. And unlike perhaps Al Gore and George Bush, who went to the courts, Jefferson was ready to invade. Jefferson was of the Democrat-Republican Party, and Aaron Burr was not quite a party member. But basically, you had the governor of Pennsylvania lining up troops on the border, ready to invade the federal district if Jefferson didn't get it. I am not exaggerating. We came this close to a civil war. This close to a civil war 12 years into our nation. Had that happened, our nation would have been gone. I mean, poof. Forget the Civil War. We've never made it that far. So what saved the day? I think there were 26 rounds of balloting in the House. And each time it kept tying. They kept tying for Burr, and they kept tying for Jefferson. And then finally, I think it was some guy in Delaware changed his vote. Apparently, he was bought off by Jefferson. He gave him a lighthouse or something, right? I'm pretty sure that's what happened. Jefferson gave him a lighthouse, and he said, "Okay, I'll change my vote." So Jefferson becomes president. Okay, so we avert one catastrophe, because that would have been really bad. There would have been a civil war if Burr was chosen as president. All right? But that's not over. Under the old Constitution, you had the election in November, and then you had the president inauguration in March. So you have what's called a lame duck session, right? Basically 3 months where John Adams was still president, and his party, the Federalists, were still in Congress. Okay? The Federalists had lost the election, and they were done. So let's see, where was I up to? They calling yet? Is that Elliot? So Elliot, you're John Adams, right? You're a Federalist. You just got your butt beat in the election. And your party has just been swept out of power. You have like 3 months left. What are you going to do? How do you do that? Okay, good. So John Adams was no fool. I mean, he was a very brilliant man. And he says, okay, I got an idea. We have this Constitution, which creates all these federal judgeships, right? And these federal judgeships last for life. So even though my tenure is over like in a couple months, I'm going to put as many judges as possible. I'm going to ramp through all these judges. So these became known as the midnight appointees, right? At the last minute in February of 1781, the last minute, John Adams appointed all these judges, and the Senate confirmed them. Okay. He also passed something called the Judiciary Act of 1781, which created even more judge positions, and he filled those also. So if you imagine, the Federalists in Congress created all these new positions for judges, and then filled them with all these Federalist judges, right? They were trying to basically pack the bench and make a lifetime majority for the Federalist Party. One of these judges you may have heard of. So at the time, President Adams had a Secretary of State, a guy named John Marshall. While John Marshall was serving as Secretary of State, John Adams appointed him to be the Chief Justice of the United States. By the way, never say Chief Justice of the Supreme Court. The title is Chief Justice of the United States. Everyone gets that wrong all the time. Okay? Chief Justice of the United States. So, John Adams appoints John Marshall to serve as Chief Justice. But John Marshall never resigned as Secretary of State. Amanda, can you be both the Secretary of State and the Chief Justice of the United States at the same time?
Apparently
You can. So there's something in the Constitution called the incompatibility clause, right? Which says you can't be a member of Congress and the executive branch at the same time. So you can't be a member of Congress and be the Secretary of Defense. But there's nothing stopping you from being a federal judge and a member of the executive branch. In fact, if you want to, the president can appoint himself as the Justice of the Supreme Court. There's nothing stopping him. It's been considered before. William Howard Taft considered appointing himself as a justice and resigning, but didn't happen. So anyway, you have all these judges being appointed, right? But as often what happens when you procrastinate is that you don't get everything done on time, right? I'm sure you've all had some sort of legal writing memo that you finished writing, but maybe you didn't submit on time. I had this one thing in law school. It's actually happened. On the day a legal writing memo was due, 15 minutes before, someone pulled the fire alarm, and the entire building was evacuated. Really dumb. Really dumb. Anyway, don't do that. So you have, all these judges who are basically nominated at the last minute. And not all these judges were Article III judges. In other words, they weren't all lifetime tenure. Some of them were called justices of the peace, which, if you know, they do like small stuff, but they have a 5-year term. One of these guys, his name was William Marbury. He was appointed as a justice of the peace in the District of Columbia. It was actually in Alexandria, Virginia, if you know where that is, but at the time that was in the District of Columbia. Okay, so here's the process, right? President Adams nominates Marbury. The Senate confirms Marbury. Okay. Then the third step is that President Adams basically signs off on a piece of paper saying, right, I accept Marbury as the judge. These 3 steps are very important, and we'll get to them later. But effectively, the president can't do it himself. He has to nominate, put a name forward to the Senate. The Senate approves him. And after the Senate approves him, President Adams signs off on it. Okay? At that point, 2 things have to happen, one of which makes sense, one of them probably doesn't make much sense, right? The first thing that has to happen is that the seal of the United States has to be put on it. Now, what is this seal? Well, most of you probably never even sent a letter, right? But in the event you actually sent a letter, you probably licked the back of an envelope. If any of you have ever done this, Some people have never actually mailed something, right? In the olden days, there was no adhesive. So what you actually had was this huge stamp. And you would take a glob of wax on the back of the letter and like, boom, stamp it. And that was how you know that the document was signed and sealed, because it was closed. And that means it was the official seal of the United States. Right? This is how you prove that something was an authentic document. You put this huge wax, and you went slamming it down. Okay? But after the document has been signed and sealed, what's left? Who knows the song? Signed, sealed, delivered. Yes, yes. Okay, Ray Charles, right? Yeah. Stevie Wonder. Okay. Signed, sealed, delivered. Right? That's the song. Adams signed it. The Secretary of State was supposed to seal it, and then it had to be delivered to Marbury. Okay. But was it ever delivered? Is that Alana? Oh, Elena. Elena. Was it ever delivered to Mr. Marbury? It's not a guessing thing, you know? Okay. Is that Jennifer? Jennifer, was it ever delivered to Marbury? Why was it not delivered?
Apparently the person that was supposed to send it didn't.
Right. Who was that person who was supposed to send the commission to Mr. Marbury? Who was it?
Some guy.
Not some guy. You know his name.
Madison.
Not Madison. If you're going to give answers, make sure they're right. Not Madison. That's Megan? Well, who in the Adams administration was responsible for delivering these commissions? Everyone, shh. One at a time, one at a time. Who was responsible for putting the seal on the document? This is actually important. I don't mean to dwell on stupid facts, but this is important. Who put the seal on the commission? Yes! John Marshall, the Secretary of State, was responsible for putting the seal on it and delivering it to Marbury. Did John Marshall ever do that? No, why not? Pretty much. They ran out of time, right? Right before. So imagine it's the last night when John Adams is the president. He signs all these things, and then they're stamped by Marshall, right? Then John Adams goes to sleep. He wakes up at 3 in the morning. Why does he wake up at 3 in the morning? He wants to get the hell out of town. He hates Jefferson. He doesn't want to be in the same state as him. He wants to get scram, right? He basically leaves the White House at 3 in the morning. He doesn't want to be there, okay? He's an odd duck, okay? But in this haste, Marshall, who at the time was also the Chief Justice of the United States and the Secretary of State, fails to deliver what's called a commission. A commission, if you're ever in the military, the commission basically says that you have this office, that the office of the judgeship is yours. Okay? So, thank you, Megan. What's your name? Mary? Okay. So, Mary, what happens after Adams skips town? What happens to that commission? Why? Who's the new president?
Jefferson.
And what does Jefferson say? Who's that person who's supposed to deliver it? Exactly. James Madison. Mr. Publius, right? One of the Federalist authors. He's now the Secretary of State under President Jefferson. Okay. And Jefferson says, hey, Madison, don't deliver that commission. Throw it out. Okay. Why? Sorry, your name's on the sheet. What's your name?
Joe.
Joe. Why does Jefferson tell Madison not to deliver the commission?
He doesn't want a bunch of extra Federalist judges there.
Exactly. Jefferson's like, wait a minute. This is shady business, right? Madison pushed all these through at the last minute when he was a lame duck. I'm not going to respect that. So you know what, Madison? Any outstanding commissions that haven't been delivered, toss them in the trash. Burn them. I don't want these Federalist judges. Okay? Everyone see what happened. He said, I'm not going to deliver you the commission. So did Marbury ever get his commission? No. Okay. But Jefferson didn't stop there, right? When he came to power, it was cleaning house, and I mean that in every sense of the word. Almost immediately, the new Congress, which was controlled by the Republican Democratic Party, repealed the Judiciary Act of 1801. In other words, all these new judge positions that were created were eliminated. Jefferson said, you know what? We're eliminating you. Now, didn't you just tell me that judges had lifetime tenure that couldn't be gotten rid of? Well, basically, Jefferson said, you know what? I'm eliminating your position, so you can go home. He just got rid of the judges. Can he do that? We'll come back to that later in the case of Stuart versus Laird, which was a short decision. But basically, Jefferson said, I'm getting rid of all of you. What about the Supreme Court? President Jefferson suspended the Supreme Court's term. He basically told them, you know what, guys? 1802 is a good year. You're not going to meet. Don't meet. He basically blocked the Supreme Court for an entire year from getting in the way of his agenda. Jefferson is a conflicted man. I mean, we can talk about him for an entire semester. But his actions here were basically saying the Supreme Court and the Federalists were acting out of line. And as the executive, I get to decide what the constitutional duty is. There was a letter you read later from Jefferson to Abigail Adams, where he basically said, hey, Abigail, this is John Adams' wife, right? Hey, Abigail, why is it that the courts get to decide what's constitutional? I'm the president. I take an oath to support and defend the Constitution. Why can't I decide what constitutional is? So Jefferson had a very executive-centric focus of constitutional law. And you know who he hated? John Marshall. Almost as much as John Adams. But Jefferson hated Marshall with a passion. That's why he suspended the Supreme Court's term. In fact, he'd actually tried to impeach another judge, and they were going to impeach John Marshall, but it never came together. Okay? So the entire case of Marbury versus Madison, actually, was filed in 1801, but wasn't decided until 1803. Because Jefferson basically said, you know what, 1802, not going to happen. Go home. Nice time to be back in Virginia. Leave. But then the case arose. Okay, now let's be very precise, and this is actually important, okay? Is that Crystal? Crystal, what did Marbury do after he was not given his commission? And be very precise. Where? Yes. Okay, so let's stop there for a second. He filed his suit originally in the Supreme Court. Okay. Now, at that time, Congress had created lower courts. There were circuit courts all over the country. Crystal, did he ever file it in one of the lower courts? Did he ever file something in a state court? Where did he file it? Okay. Why? Is that Hector? Hector, why did he file his case originally in the Supreme Court?
Well, I think probably because he thought he might have a good chance to win the Federalist controlled court.
Ooh, you gave me the right answer but in the wrong order. Okay, that's a good answer. Because think of what just happened, right? Jefferson had just abolished all the other courts. He basically kicked out of office all the other Federalist judges. But he knew the Chief Justice was Marshall. Okay? So we didn't discuss this, but I'll come back to it. What's the purpose of jurisdiction? Is that Connie?
Jurisdiction is the power to judge on an issue.
Good. What's the importance of jurisdiction, though? Why is that so important?
You have the power to have the authority to execute.
Where do courts get jurisdiction from? Sorry?
I was going to say the Constitution.
That's right. Or?
Or the Congress.
Okay. So let's take a look at Article 3, Section 2. And if you have your constitutions, you can, which you should have. If you lost it, I'll give you a new one, but only one freebie. It's on page 31, right? Okay. So Article 3, which we'll be turning to again, you might want to fold over the page 31, right? This defines the jurisdiction of the court. So it says, I have it up here in case under Constitution, the judicial power shall extend to all cases in law and equity arising under this Constitution. Okay? Is that Vicky?
Yes.
What does that mean, that first sentence? The judicial power shall extend to all cases in law and equity arising under this Constitution? What do you think that means?
I guess to interpret the Constitution.
Well, that's a good interpretation. What do you think that means? Is that Alita?
Later.
Alita, what do you think that means, that first sentence right there?
That anything arising from a constitutional issue could be governed by rulings of the Supreme Court.
What does this mean, arising under? We'll get to this later. Is that Michelle?
Yes.
What does this arising under mean?
It's an issue that is relating to something.
That's good.
violating the
That's
Constitution.
good. That's a good definition. The court has grappled with these words for almost 200 years. So I'm not expecting a perfect definition. That's pretty good. So the courts, the federal courts, right, have some sort of power to consider cases involving, something involving the Constitution. Okay? So basically, the Constitution defines this broad judicial power. But it also says Congress shall make. Okay? So you've probably said this in Civ Pro, but not from this angle. If we picture like jurisdiction as this broad pie, right? Is Congress required to give federal courts all that jurisdiction? Is that Maria? Is Congress required to give federal courts all the jurisdiction in the entire Constitution? What are they actually obligated to give? It's a trick question. Exactly. With respect to the lower federal courts, the inferior courts, if you will, right? Congress need only give to those courts as much jurisdiction as they want, right? And Adela, why would Congress not want to give these federal courts so much jurisdiction? What might their reasoning be? Why would a court want to limit it? Why would Congress want to limit the jurisdiction of a court?
For power reasons, to check the ambition.
Good. One of the key limits on the ambition of courts is jurisdiction. Courts can't decide whatever case they damn well please. Courts can only decide cases where Congress and the Constitution have allowed them to. This is such an important check on judicial ambition that people don't appreciate. This is why jurisdiction is so important. When a court lacks jurisdiction, the answer is dismiss. Done. Dunzo, right? The fastest way to get out of court is if you find there's a lack of jurisdiction. Kaput. This is a serious check on judicial hubris. Okay? But the Constitution gives Congress broad power of the jurisdiction of the federal courts. Indeed, we said they were not even required to create lower federal courts. They could have said, nah, we don't want any. We'll just keep the Supreme Court. But the Constitution is very precise for the Supreme Court. And this is what's important here. The Constitution creates the Supreme Court. Congress can never eliminate the Supreme Court, no matter how much they might want to. Not only that, the Constitution defines two types of jurisdiction for the Supreme Court. You have the original jurisdiction of the Supreme Court, and you have the appellate jurisdiction of the Supreme Court. And we've discussed at some length, right? Appellate jurisdiction means you are appealing from some of the lower court. Now, I tried to trick you saying, well, there were no federal lower courts. Well, this court, the Supreme Court said that means there's appeals from a state Supreme Court. Say you're in the Virginia Supreme Court, you don't like your judgment, go appeal to the US Supreme Court. That's not obvious from the Constitution, right? That doesn't necessarily follow. But the Supreme Court said, listen, if we have appellate jurisdiction, it's got to come from somewhere. And if Congress never created lower federal courts, where's it going to come from? From the state courts. Now, a better question is, are states required to have courts? That one for later. I think the answer is no. Okay? But the original jurisdiction of the Supreme Court, right? These are certain matters that are of very important national significance. Here, you go straight to the Supreme Court. Okay, so what are they? In all cases affecting ambassadors, and that makes sense, right? If there's a case involving an ambassador, you don't want that in some random dinky court somewhere in New Jersey, right? You want that in the national capital. Okay? Public ministers and consuls, those are basically ambassadors. Also, cases in which a state shall be a party, right? So basically, if a state sues another state or someone sues a state, you want a disinterested court, right? You want the Supreme Court of the United States to resolve it, right? So there's only a couple things. I mean, really, you can count them like 3 or 4 things that get you to Supreme Court's original jurisdiction. Everyone get that much, right? That's Whitney? Whitney. So when Marbury filed his lawsuit in the Supreme Court's original jurisdiction, what did he seek? What was the remedy he wanted? What's that thing called? Mandamus. What is mandamus? They want to look it up. Yeah. Oh, perfect. You're next.
Judicial writ from a upper court to a lower court.
Close. Good. Okay. So, by the way, if you don't know a term, look it up in general. But yeah, thank you, Dave. That's good. Mandamus was a writ. And what's a writ? In the old King's Law, this was an order that one branch gave to another. So in this context, it was basically an order. Okay. Marbury wanted an order. In order for what to happen, Alejandro?
For the commission to be delivered
by
Madison?
Madison. That's why the case was Marbury versus Madison, right? You ever think about that? Marbury was suing Madison to deliver his damn commission. He's like, listen, I want my job. Let me come to work. I can't come to work unless you give me this stupid piece of paper, right? Give me my commission. So he filed a lawsuit, okay, in the original jurisdiction of the Supreme Court, seeking a writ of mandamus. Okay. So now over here, is that Sean?
Yes.
Sean, do you see anything in the Article 3 of the Constitution, anything that gives someone the right to sue for mandamus in the Supreme Court's original jurisdiction? Is there anything? Just in Article 3.
I guess the answer is no.
Why is the answer no? That's correct,
No.
but why is the answer no?
The Supreme Court decided that they
No, don't give just the text, right? Looking only at the text right here. This is all I'm looking at. Is there anything there that says in the original jurisdiction of the Supreme Court you can sue on mandamus?
No.
Answer is no. Okay. That's correct. So why is that Andrew?
Nephew.
Oh, Nephew, you're not on the list. If you didn't put your name on the list, please come up afterwards and add your name. Okay, Nephew, why did Marbury think that he could sue on mandamus in the Supreme Court's original jurisdiction? What gave him that? What gave him that crazy idea?
He felt that the court had the jurisdiction.
Right. Why did he think the Supreme Court had that jurisdiction? Because it's not in Article 3, right? It's not in Article 3. Where did he get that answer from?
I'm actually not sure why.
Is that Andrew?
Yeah.
Andrew, where did Marbury get this idea from that he could sue for mandamus in the Supreme Court's original jurisdiction? Where did he get this idea from?
Didn't it say that in the Judiciary Act 17?
Exactly. And if you were cheating, you could see it was the next thing on my list. Anyway, the Judiciary Act of 1789. Okay, this was one of the first things Congress ever did. Almost immediately after the first Congress met, the Constitution had just been ratified, right? They enact a Judiciary Act, and this creates the lower federal courts. So we were saying, oh, there was no requirement for Congress to create courts. Well, of course they were going to. One of the first things they did was create lower courts. But they did more than create lower courts. One section of the Judiciary Act, I think it was section 11 or 13, I can't remember. One section of the Judiciary Act said, we authorize the Supreme Court to issue writs of mandamus, blah, 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 to any person under the authority of the United States. Okay? So is that Caleb?
Yes.
Caleb, sir. Under this reading, right, if you take just the statute, was Marbury correct in suing in the Supreme Court to order James Madison to give him his commission? Just reading this.
Yes.
How come? What does this section do? What does it authorize?
It directly relates to the position he was trying to.
Exactly, right? Basically, it says you can issue these writs of mandamus where it's appointed by law to any person holding office. So if I'm William Marbury and I'm a smart guy, I'm a judge, I read this law from 17, I'm saying, hey, listen, look, there's some legal obligation, right? Jefferson was obligated to give me this commission. He didn't do it, so I'm going to sue for mandamus in the Supreme Court and order Madison to give it to me. Sounds easy enough, right? What happens next will blow your mind. It's like a BuzzFeed handle, right? But seriously, this will blow your mind, and I'm not exaggerating too much. Okay. So everyone get the argument, though, right? Saying, listen, the Supreme Court says, Congress says I can sue the Supreme Court for, mandamus to order Madison. Okay, there's a couple questions or a couple problems with this, right? Is that Brandon? Let's start with this, right? It says principles and usages of law. Is there any law that requires Jefferson to give him the commission? Is there any obligation under the Constitution for President Jefferson to deliver the commission signed by Adams?
No.
Why not?
Because now he was the president in term.
So is there any requirement for Jefferson to actually deliver this commission? What do you think? Is that Jocelyn? Is there any requirement for President Jefferson to deliver the commission to Marbury?
No, not Jefferson.
Or at Madison, let's say Madison.
Yeah.
Why do you think he's required? Where does it say in the Constitution says he has to deliver it?
Part of his job is when the president
Is that in the Constitution? Well, let's be precise. There's actually not Constitution, it's a statute, right? The statute says that the Secretary of State is required to place the Great Seal. Place the Great Seal on the commission, right? That's what the statute says. Statute says nothing about delivering it. What do you think? Is that Stephanie?
Yes.
Is the Secretary of State required to actually deliver the commission? Any legal obligation?
I guess he has a right to receive the commission.
Okay, so you both said things that are correct. There's no doubt that Marbury has a right. He has a right to the commission. It's his, right? The president appointed him, the Senate confirmed him, and then the president signed it, and then the seal is placed on it. So he has what's called a vested right. You'll hear this word a lot, but a vested right. He has a right to the commission. But here's the beauty of the case. If there's a right, does there have to be a remedy? You'll hear this over and over again. You often hear people say, where there's a right, there's a remedy. What does that mean? Juan?
Yeah, I mean, if when you go to court, you bring something up, you want the court to do something about it.
So if someone wrongs you, a court will be able to fix it, right? We generally think that's true, right? Where there's someone wronged me, the court should be able to fix it. But is that always true? Is that Mitchell? Is it always true that where there's a right, there's a remedy?
I say not in every case.
What limitations are imposed in a court that may prevent them from issuing a remedy? What's this limitation on judicial hubris we spoke of before? Wade? Jurisdiction, exactly. The limitation imposed on courts is jurisdiction. If a court lacks jurisdiction, they cannot give the remedy. If a court is without jurisdiction to issue an order, they say, sorry, buddy, you got a rough shot, but we can't help you. So this case can be looked at many levels. But at one level, Marshall says, where there's a right, there's a remedy. And he basically accepts the fact that once the seal was placed on the commission, he had this vested right. But the remedy could not be given. Okay, and why could the remedy not be given, Marianne? Exactly. The remedy cannot be given because the court lacked jurisdiction. The remedy could not be given because the court lacked the jurisdiction to do so. Okay? This is the brilliance of John Marshall, and I don't say that lightly. Because think about this, right? Madison? Madison, what would have happened if John Marshall said, you know what? Here we have the statute, the Judiciary Act of 1789. I'm going to issue this writ of mandamus to James Madison, ordering him to deliver the commission. What do you think Madison would have done?
I wouldn't have been very happy about it.
Oh, he would have been more than unhappy about it. What do you think he would have done?
Ignored it.
Ignored it. Did you know, it's not in the book, no one argued this case on behalf of the government. Jefferson didn't even send a lawyer to the Supreme Court to argue this case. He didn't give a damn. He suspended the court's term and didn't even send anyone to argue the case. More than unhappy. If Thomas Jefferson would have received a writ of mandamus ordering him to deliver the commission, he would have ignored it. And then we're at Central High School, my friends. We are at Central High School. Instead of President Eisenhower sending in the troops, you have the president saying, meh, flip off. This is when we have a constitutional crisis. And John Marshall knew this damn well. He knew if he had ordered Jefferson to give the commission, he would have ignored it. And that would basically render the Supreme Court a nullity. Once you ignore the Supreme Court, you know, the ball game's over. I mean, we talk about the ball game ending in 1955, could have ended in 1803. So, and this is the genius, right? He knew that at the end of the day, he could not require Madison to give the commission because Madison would have ignored him. So what did he do? He also knew that he needed to establish certain principles that would allow the court in the future to exercise some sort of review of statutes. So what he did here is a jujitsu, if you will, like, you know, this master move, right? I can't ever say that word right. So follow me here. The Judiciary Act of 1789 said, we're going to allow people to sue in the Supreme Court's original jurisdiction and sue for this writ of mandamus. Even though Article 3, okay, even though this is not listed in Article 3 as one of the things that can be done. Okay? Does this writ of mandamus, can Congress give this jurisdiction to the Supreme Court's original jurisdiction? That's the question. Can Congress expand the Supreme Court's original jurisdiction? Right? Because if Congress cannot expand the Supreme Court's original jurisdiction, that section's unconstitutional and no mandamus will issue. All right? So let's go back. Is that Daniel? Daniel, looking again at Article 3. Okay, so it lists here certain things. So the original jurisdiction is, you know, involving ambassadors and ministers and where the state's a party, right? Is there anything in there about mandamus? Okay, but now let's think more closely. Is there anything in the Constitution which says these are the only things that there can be original jurisdiction? Does it say anywhere that maybe Congress can do stuff to that jurisdiction? Keep reading. Read to the bottom of the section. Here, I'll highlight it if you make it easier. What does that say?
With such exceptions and under such regulations.
It says it right there, right? Or does it? And this is an answer which we don't have the answer to. But it says there that Congress can make certain exceptions and regulations. Now, this is the question which law professors argue over for years, right? There are two sentences here. One sentence is about original, and one section is about appellate. The stuff about the exception from Congress is in the sentence about the appellate. Does this phrase modify both of them or only one? Does Congress have the power to make exceptions to the court's original jurisdiction? I don't have an answer for this. This is something which people have been arguing about for 200 years. But the opinion of Marbury is not 100%. There's actually a decent argument that Congress can expand the Supreme Court's original jurisdiction. There's a decent argument. I don't know if it's right or wrong, but there's a decent argument. But Marshall holds that Congress cannot expand the original jurisdiction, right? Is that Ryan? Sorry, Julius. Why does Marshall say that Congress can expand the Supreme Court's original jurisdiction? What's his reasoning?
Can?
Cannot.
Because that would expand the powers that are given to it by the Constitution.
Exactly. So you all studied in Congress this doctrine of expressio unius, exclusio alterius est, right? The inclusion of some things mean the exclusion of others. Everyone know what I'm talking about? Not dreads. Okay, good. So by listing 3 or 4 things there, is that Ryan? Yeah. So by listing 3 or 4 things there, what was the Constitution trying to say by only listing these 3 or 4 things?
Wait, say that one more time.
By listing 3 or 4 things in the original jurisdiction, what was Congress trying to say about everything else?
That the Supreme Court wouldn't have jurisdiction over anything else.
Exactly. By listing these 3 or 4 things, they meant to exclude everything else. Did they mention mandamus here? No. So by failing to mention mandamus, they wanted to exclude it. Right? Therefore, Marshall holds that this section of the Judiciary Act expands the Supreme Court's jurisdiction, the original one, in violation of the Constitution. But now what? William, what happens if the Supreme Court finds that some statute does something that's unconstitutional? What happens when the justice finds that Congress did something unconstitutional?
They could call it unconstitutional, or
Well, where do they get the power to do that from?
the Constitution.
Okay. And this again goes back to our Little Rock case. Who is the final expositor, right? Who gets to decide whether something's constitutional or not? William, who gets to decide whether something's constitutional?
Supreme Court.
Why?
The people.
They're not elected.
You said all the branches together, the executive.
Why can't the executive? What if President Jefferson says, yeah, that's constitutional, and Congress says, yeah, that's fine? Why can't they decide what's constitutional?
Because the powers invested in the Supreme Court.
I'm looking at it right here. Where does it say they can invalidate laws? I don't mean to pick on you, but I'll be very precise about this. Where does it say they can invalidate laws? Nope. Yeah.
The court system would fall.
I'm sorry, the court's what?
The court systems would fall and lose their legitimacy.
They didn't have any legitimacy yet. What if the court has simply said, you know what? This statute is unconstitutional, but we lack the power to decide it within our jurisdiction, so the case is dismissed. Where do we get that from? No. Where did it come from before Marbury? What is this judicial power? How do you define this?
The ability to review cases, make decisions based on the Constitution, and decide if those rulings by Congress are constitutional.
Okay.
Because if Congress enacts a statute that's against the Constitution, then it's void. But what do we do after that? Courts have to go and void things because Congress said so.
So it's interesting. Yeah. Wow.
I was going to go back to that typical checks and balances. Wouldn't it be if Congress enacted a law that was technically unconstitutional? Could the court go back and say, well, for the checks and balances, it isn't?
Okay. So all of you said very good things. I'm going to focus on what Brandon said for a second. Judges take an oath to uphold and defend the Constitution, right? That's their oath. If they find a law is unconstitutional and they're required to then interpret the law, they're basically forced to violate their oath. This is what Marshall basically says. Like, listen, Constitution says we have the oath as judges to uphold the Constitution. I, in good conscience, can't sit here and uphold a law that's unconstitutional. Okay? But more fundamentally, right? The word judicial power wasn't created in a vacuum. Now, I'm sure all of you were taught at some point in your education that John Marshall invented judicial review. He pulled it up out of whole cloth and went, poof, judicial review. It's simply not true. English courts, for centuries, since the time leading, not quite Magna Carta, but Magna Carta-ish, have been deciding cases where something was violating the supreme law. The entire point of Magna Carta, Magna meaning great, like Magnum, right? Magna Carta meant it was the great charter, that there was a law, that the king was not above the law, and that actions of the king that were in violation of this Magna Carta were deemed invalid. So for hundreds of years in the British legal tradition, you had courts finding laws contrary to Magna Carta. You had courts finding laws contrary to the English Bill of Rights, right? One of the most famous is called Dr. Bonham's case, right, by Lord Coke, where effectively you had decisions invalidating laws of Parliament. So this was nothing new, right? It was nothing new that Congress was taking steps to the court was taking steps to invalidate it. And then we go to Federalist number Federalist 78, right? Alexander Hamilton refers to the courts as, quote, bulwarks, B-U-L-W-A-R-K-S, bulwarks of limited constitution against legislative encroachment. But Hamilton specifically says in Federalist 78 that the courts will stand in the way of the legislature exceeding their powers, right? So it was long since held that courts had this kind of discretionary power to invalidate laws that were constitutional. But what Marshall deserves credit for is this was the first time it was ever exercised. It was the first time that the Supreme Court held a law violated the Constitution. Okay? This was significant because he laid out the framework of every single case leading up to the Cooper v. Aaron, the Little Rock 9 case. Because not only did Marshall say that we as judges get to decide if the law is unconstitutional, right? He also said we're final. Because imagine what happens is if the Supreme Court says this statute's unconstitutional and Congress says, no, it's not. Do it anyway. We're back in Little Rock now. The thing falls apart very quickly. So Jefferson basically said, we decided and we are final. And no one else gets to second guess this. This isn't necessarily right. In fact, there's nothing in the Constitution which says the Supreme Court is a final expositor of constitutionality. In fact, I would argue against that. I think all members of government should always act constitutionally. It's very often members of Congress will say, well, we're passing the statute. Maybe it's constitutional or not. Let the Supreme Court figure that out. I think that should be grounds for removal. Every person who takes an oath to support the Constitution should mean it. But today, that's not often the case all around. So the magistracy of Marbury is how Marshall establishes judicial review at the same time as not forcing Jefferson against him. Basically, the way he decided this case was that Jefferson would have to do nothing. Jefferson couldn't do anything. And that was the beauty of this case. So in the end, what does the court hold? The act of signing it and sealing it was sufficient to become a judge. Whether or not he actually got the piece of paper didn't matter. He was a judge and he had a 5-year term. He actually used the example of what happens if someone sent you the commission, your house burned down. Do you lose your position? No, they'll make a copy. So the mere fact they didn't make a copy of this, it's not sufficient to deprive you of these rights. But in doing so, John Marshall invalidated an act of the very first Congress. I'm talking like people like James Madison wrote this bill. And Marbury said it was unconstitutional. Marshall said it was unconstitutional. This is a very significant and serious decision. And we will come back to it over and over again. You'll notice that in Cooper v. Aaron, the Little Rock 9 case, they cite Marbury. They're like, listen, the governor of Arkansas says that he gets to decide what the Constitution means. Nuh-uh. Since Marbury, we get to decide what the Constitution means. Marbury isn't necessarily right. And I want you to make sure you remember that. But it is the basis of our entire judicial system. And every time I ask you, right, why do people listen to courts? Go back to Marbury. Think of what happens if Jefferson was ordered to deliver the mandamus and he said no. Our country would look very, very different today. Now, the flip side to that is when courts start doing too much, they do have the temptation of tyranny themselves. And we'll discuss at great length what happens when courts go too far and aggrandize too much power. Okay? So questions on this? Questions on Marbury? Yes, sir.
You said this was the first time that the Supreme Court nullified an act of Congress?
Yes. Overstated, yes. There are other little things, but pretty much yes. Okay? So, other questions? So there's another case, there's a brief one, less than a page afterwards, called Stuart v. Laird, right? And this was the case that everyone thought would be the big deal, right? So if you recall, I said that after Jefferson took power, basically the Congress eliminated all these judgeship positions. So there used to be this court called the Fourth Circuit, and they got rid of it, and now they have a new court called the Fifth Circuit with all these Republican and Democratic judges. So you had a case, it was a fairly simple case involving a bond, amount of money. And basically, when the case was filed, it was before all the Federalist judges, the Fourth Circuit. But when the case was returned, it was in front of the Fifth Circuit, all these Republican Democratic judges. And one of the guys saying, hey, listen, these aren't the right judges. I want my Federalist judges back because they would have been more favorable to him. So this case could have really messed things up. So imagine if the Supreme Court had said, yeah, John, yeah, you can't eliminate all these judgeships, put all these Federalist judges back in power, and, oh, get rid of all these other Republican judges. Okay, that would have been cause for civil war. It would have never been followed. So in this case, the Supreme Court basically said, well, you know, whatever. And I'm not exaggerating. The court didn't really have much analysis. This was decided the week after Marbury. And basically what the court said was, yeah, nothing prohibits Congress from transferring cases, so this is okay. They view this as Congress transferring cases from one judge to another. And they totally ignored the fact all these judge positions were eliminated. Right? All these judgeship positions were just, poof, gone. The Supreme Court dodged a bullet here because had they ruled against the government, they would have been ignored. And again, we're back in Little Rock High School. Okay, so this was like the whimper after the bang of Marbury. All right. So questions on this? Yes?
Is there a reason that the Supreme Court doesn't, I mean, is there a political reason behind that?
Doesn't what?
Doesn't have controversy with the executive branch?
Oh, they do have controversy with the executive branch.
Doesn't pull them into it. I read something about SCOTUS not doing something.
So, by the way, SCOTUS, Supreme Court of the United States, for those of you who don't know, so SCOTUS, yes, go ahead.
With Nixon and the Vietnam War, or Bush with the war on terrorism, I mean, there are constitutional questions that arise with those sorts of executive power. And there's an argument that the judiciary hasn't acted because they don't wish to have that conflict.
Okay, I'm glad you mentioned this on the first or second class of the semester. One of the themes we'll discuss this entire year, right, is a relationship between the courts and the people. And Hamilton alludes to this in Federalist number 78, right? The courts have no power of the purse. They have no power of the sword. All they have is judgment. And that judgment only exists so far as people respect it. People think it's a legitimate judgment. Now, we discussed one extreme, right, where the court is, enforcing the Constitution, saying you have to desegregate these schools. And I think everyone in this room would say, yay, go Supreme Court, right? But what happens when the Supreme Court goes in the opposite direction? And they do something they're not supposed to. And they try and decide issues they shouldn't. I'm talking about Dred Scott. We'll talk about Dred Scott later. But Chief Justice Roger Taney thought that he could avert a civil war by saying that slavery was constitutional. That's what he thought. He thought that if he made a decision upholding slavery, it would save the nation from a civil war. He was wrong. Wrong, 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 wrong. Wrong so much that Maryland, his home state, won't even honor him anywhere, right? Try and find a statue of Roger Taney in Maryland, you won't. Okay? I think there actually might be one, but basically they ignore him. Okay? When the courts act out of line, the other branches can push back. So one of their examples we'll discuss over and over again is the New Deal, and some of you may have studied this. During the New Deal, President Roosevelt pushed forward a number of laws that greatly expanded the power of the central government in ways that were entirely inconsistent with what the Supreme Court had previously upheld. The Supreme Court, in a number of cases, basically invalidated his programs, and Roosevelt didn't take that sitting down. Okay? What happened? He threatened to pack the court. He basically said, like Jefferson before him, you know what? I don't want all these old Republican judges. I'm going to put my own guys in the court. We'll let all of you go out to pasture, right? And I'll put on 9 of my new guys. He threatened to basically replace the Supreme Court. So the court does not operate in a vacuum. When they issue decisions that conflict with various senses of the will of the people, and we'll define that, when these decisions are out of scope of the will of the people, this is very precarious, because if the executive branch pushes back, like Roosevelt did, or if the states ignore them, like in Arkansas, right? Or if you start a civil war, like Roger Taney, you threaten to lose the entire court and the entire nation. So the judges of the Supreme Court, in addition to interpreting the law, use the word political. I'm not going to use that word. I don't like that word. But they definitely have a duty of higher power to understand how their decisions fit in with the greater scheme of separation of powers. And it's a duty which I firmly believe they each take very seriously. I don't agree with the justices all the time, but I firmly believe that they take their role very seriously. And it's an important position in our separation of powers. We'll discuss at various points how different judges perhaps have done that more so or less so than they're supposed to. But the issue of the judges using their judgment in a way to be more or less in sync with the rest of the nation is something which is a skill that the court has not always employed. All right, any questions? All right, we did the entire class, got you all today. We'll start with you back on Monday, okay? All right, have a great weekend. I will see you all soon. And if you didn't put your name, please come up and write your name on the sheet. Thank you.